Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Mishegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Good morning, my friends. And thanks so much for coming to hang out with me today. Today is Tuesday, March 18th, 2025. And today we go back to Dedham. We're going back to Dedham for a full day of hearings. I think it's supposed to be a full day of hearings on the Karen Reed case. There's a lot of motions in limine. A lot of motions in limine to hear about and to talk about and to listen to today. So how is everyone this morning? Did anybody watch the documentary last night on ID? The man passed out in the snow documentary. Interested in your thoughts on that. Oops, let me just get Boston 10 ready. How are you guys? New members, Angel, welcome for coming in from Australia, and also for gifting 5 memberships so early this morning. Thank you so very much for that. I appreciate you. And to the 5 new members, welcome. Jody, well, thanks for becoming a member, and welcome to you. And also Gino, thank you so much for becoming a member, and welcome to you. On top, thank you for your stickers. Super sticker as always. I haven't had enough coffee yet, as you can see, but I'm getting there. There is one motion that came in yesterday after we finished our marathon of however many hours we were here going over the motions in limine, and it is a buffer zone motion. They're looking for a new buffer zone, a bigger buffer zone. And they also want a court order giving the law enforcement outside of the courthouse the ability to use reasonable force against anybody who breaks the buffer zone rule. I'm sorry, are we in some sort of third world country? Like what? Anybody see that by that motion? It's a little bit strange, a little bit odd. Let's take a look at that real quick. I don't know if that they'll get to that one today. Yeah, North Korea much. Yeah, let's take a look at that quickly. We have until, let's see, we have about maybe 11 minutes. I have Boston 10 on today because typically their sound is better than Court TV or Law and Crime. But I have to sit through this commercial first before it will reset. Here's the buffer zone motion. So this is docket number 611. Docket number 611. This was filed yesterday. It says around noon, but it wasn't scanned in until later in the day because I think we finished yesterday around what time? I don't remember, 2:30 in the afternoon, and it still wasn't up. So this is the Commonwealth's motion for a buffer zone and order prohibiting signs or clothing in favor of either party or law enforcement. This is a Commonwealth motion. And yeah, we can all do better than those numbers. Hit the like button. Oh, the camera's up in Boston 10, but it's not focused on anything yet. So let's just take a quick look at this before we move on. They go on to say that during defendant's first trial, the court established a buffer zone in which demonstrators were prohibited within 200 feet of the courthouse complex. Many of you were there, so you know about this. The Commonwealth requests that this buffer zone be reestablished for the defendant's upcoming retrial, but with two important modifications. First, on the western side of the courthouse facing Court Street, the extent of the buffer zone was inadequate to prevent such demonstrations from jeopardizing the integrity and fairness of the proceedings. The demonstrators or the demonstrations could be heard inside the courthouse, including by the jurors, during the lost my place during their deliberations. And I think I don't know if one of the jurors said that. I'm not sure that he said they could hear it during the deliberations, but that's what Hank is saying here. To prevent this from reoccurring, the Commonwealth requests that the buffer zone be extended to include the area encompassed within Bates Court, Bullard Street, Ames Street, and Court Street. Second, the Commonwealth requests that the court buffer zone order expressly include a mechanism for its enforcement where a person is believed to have violated the buffer zone provision and has refused requests to comply. Law enforcement personnel should be authorized to use reasonable physical force and to arrest that person to ensure compliance. Um, Okay, moving on. Additionally, the Commonwealth requests that the court again order that individuals are not permitted to wear or exhibit any buttons, photographs, clothing, or insignia relating to the case or to any trial participant in the courthouse during the retrial. Background. On March 26, 2024, the Commonwealth moved for an order barring demonstrations within a buffer zone of 500 feet around the courthouse complex and prohibiting certain items from being worn or displayed inside the courthouse during the defendant's first trial. A group of individuals moved to intervene in the case to oppose the Commonwealth's request. The ACLU of Massachusetts sought leave to file an amicus curiae memorandums, essentially in opposition to the request. The defendant took no position on the matter. Following a hearing on April 4th of 2024, the court denied the motion to intervene, granted the ACLU Massachusetts leave to submit its memorandum, which the court noted it had read, and ordered that, quote, no individual may demonstrate in any manner, including carrying signs or placards within 200 feet of the courthouse complex during the trial of this case unless otherwise ordered by this court. This complex includes the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Registry of Deeds building. Individuals are also prohibited from using audio enhancing devices while protesting, like bullhorns. And no individuals would be permitted to wear or exhibit any buttons, photographs, clothing, or insignia relating to the case pending against the defendant or relating to any trial participant in the courthouse during the trial. Law enforcement officers who are testifying or are members of the audience are also prohibited from wearing their department-issued uniforms or any police emblems in the courthouse. Then they talk about the would-be interveners who filed a petition for extraordinary relief, and the single justice of the SJC denied the petitions. The petitioners appealed the single justice's judgment to the full SJC, and the full court issued an order affirming the judgment, and on May 2nd, it issued an opinion stating the reasons for that order. Moving on. Here's their discussion. The factual circumstances and concerns that necessitated the creation of the buffer zone last time are no less present or compelling today. The case continues to garner significant public interest and media attention locally and nationally, and is the subject of commentary on various social media platforms, including this one. The proceedings are still attended by groups of individuals demonstrating in front of the courthouse, displaying references to materials that may or may not be introduced in evidence at retrial, and airing their opinions as to the trial judge, prosecutors, witnesses, and the guilt or innocence of the defendant on their clothing and or on signage. Shown below, for example, are photographs of demonstrators who appeared despite the inclement weather at the hearing on February 6th of 2025. And they have a picture from February 6th of about maybe 20 people outside the courthouse. And then they zoom in on the signs that say, Morrissey McAlbert, Federal Prison 2025. And this sign, which says, boots on the ground, ain't backing down. And then there's a sign here that says, honk for justice. In addition, and as the court found when it issued the buffer zone order, protesters have shouted at witnesses and have confronted family members of the victim. Witness intimidation also remains a prevalent issue in this case, with additional criminal charges having been filed earlier this month. See Commonwealth versus Aiden Carney. Okay, remember the incident where apparently Will DeGlaire and Aiden Carney were with a couple of other people, and they went to CF McCarthy's for dinner, and then after they were done eating dinner, Aiden went next door to D&E Pizza, which is owned by Chris Albert, and looked in the window of D&E Pizza and allegedly was talking right at the camera and said some things to the camera. And apparently Chris Albert also has audio recording outside of D&E Pizza, which is apparently against the wiretapping law in Massachusetts. Better wrote a letter about it. But does it give you any indication as to why they really, really wanted to get Aiden Carney on something else so that they could maybe throw this into their buffer zone motion and or revoke his bail? He's going to be in court today in Stoughton at noon, and it's unknown whether or not they will revoke his bail and throw him back into jail. So there's that. See also the affidavit of Juror Doe describing efforts by individuals to intimidate, harass, and dox jurors following the declaration of the mistrial. The reestablishment, they've got some weird music playing in the courtroom. I'm not sure why. Actually, that weird music is coming from somewhere else in my headphones. Hold on. Oh, that's the Law and Crime feed, right? We don't want that. The Court TV feed, rather. We're going to use Boston 10 today. The reestablishment of a buffer zone is therefore necessary to help ensure that both parties receive a fair trial, free from outside influences. During the first trial, the 200-foot extent of the buffer zone was adequate to prevent any demonstrations occurring on the southern, eastern, and northern sides of the courthouse complex from interfering with the proceedings inside the courthouse. See affidavit of Massachusetts State Police Sergeant Michael W. Hardman. Well, that's interesting. Why didn't they use an affidavit from Trooper Fanning if he was the one, the head mofo in charge of security? They're using this guy, Sergeant Michael Hardman? Okay. On the western side of the complex, however, it proved to be inadequate. On that side, there are larger open spaces that extend beyond 200 feet from the courthouse. In particular, the paved and grassy areas alongside High Street, between Bullard and Ames Streets and Court Streets. These areas are shown in the Google Maps screenshot below, along with a red line superimposed to indicate the extent of the 200-foot buffer zone on that side of the complex. Enter the grassy knoll. And then they have a screenshot from Google Maps that we really can't see because it's not in color, and I don't know where the red zone is. The red line is that they're talking about. Groups of demonstrators gathered in these areas, presumably with the property owner's permission, and engaged in coordinated shouting and chanting aimed directly at the courthouse. Even when standing just outside the buffer zone, these demonstrators could be heard inside the courthouse, including during deliberations. the affidavit of Juror Doe. During jury deliberations, we could hear protesters outside screaming and yelling. As another consequence of the 200-foot extent of the buffer zone, individuals positioned in these areas were close enough to court and Ames streets to encourage passenger and commercial vehicles traveling on those streets to honk their horns as a form of demonstration. This happened repeatedly, and the honking, especially from the air horns of the commercial vehicles, could easily be heard inside the courthouse. Footnote 1. This continues to be a demonstration tactic as shown in the above photograph of the individual at the February 6th hearing who is holding up a sign that says honk for justice. Frequent honking has occurred at nearly every hearing in this case over the past several months and has been clearly heard, audible in the upstairs courtroom. They go on to say, we're going to switch to the court feed right now, that they gave out many tickets for people who were honking their horns. Welcome to Massachusetts, my friends, where the First Amendment is no longer, or maybe never has been, alive and well. I'm not sure, but here's AJ, Alan Jackson, smooth as butter. We have an emoji for that. Right, finally an affidavit. Finally. Imagine that. Right, what about the sirens? Do you want them to stop? Exactly. Jay Pearl says if people weren't outraged, there wouldn't be any honking. Well done. There's Misty and Eddie. Aiden Connie in the courtroom until he's got to go over to Stoughton for his 12 p.m. appearance. There is, I see Esty. I spy Esty. I spy. Wait, who's this guy? Who's this tall guy? Because he looks familiar. I think I saw him in that. Did I see him in that documentary last night? I don't know. There's Karen, looking lovely. Talking to Aiden. Thanks, Angel, from Australia, for gifting the 5 memberships. I think I did thank you. Thank you, Michelle Monaghan, for your super sticker. Sons, thank you for thanking me and for being here for 9 months. Here's Karen. The Goodmans are here. They gifted 5 membership. Thank you, Goodmans. Love you guys. Sound is coming up. Oh, thank you, Ms. Jules from Florida, for the $50 super chat. Says nothing compares to you. Name that tune. That's the one. Isn't that the name of it? Nothing compares to you. Thank you for being so generous this morning. I appreciate you more than you know. Karen Reed Strong became a new member. I'm not talking over anything. It is just courtroom chatter right now. Team Brittany is here. She's an amazing moderator, an amazing human, and she's here to remind you, keep any outside drama out of the chat. No insults to others, rude comments, family relationships and marriages, etc. Thank you all for keeping the chat classy. And for the one person who may have been timed out yesterday, that warning had been up on the screen at least 10 times. And so perhaps that is why you were timed out.
Welcome to Zoom.
Sorry, I just can't play that drama game, and I'm not going to allow anything defamatory in my chat. So I appreciate you guys. There's Kelly Reed. Karen's, actually Bill Reed's cousin. She's sitting back here. That walking up front was Laura McLaughlin.
And will be muted throughout the meeting. The host would like you to...
Dev's Albuterol is here. Thanks for the 10. I told the mister I was going to the grocery. He sighed deeply and said, I'll allow it. Last night, I sat dinner on the table and he said, you're all done. I pretend not to have eye spasms, so he'll stop. That's hilarious. Thank you. Where would you have pulled Will and Aiden by the ears? Oh, thank you, On Top. On Top, I did say that last night when I went on Glare's stream. He did a 12-hour fundraiser for the Karen Reed Defense Fund. I can turn off this chatter for a second. And they raised over $20,000 during that 12-hour stream. Does anybody know what the final total was? I think it was something like 22,000, maybe a little extra. And when I made my appearance on there, Aiden and Will were both on, as was Olivia Nile, aka Olivia Lambo on Twitter. And I said, we were talking about, or Aiden was talking about his new charges. And I said, listen, for the record, you two, if I'd have been there with you guys, at CF McCarthy's. Number one, we never would have been to CF McCarthy's because I would have said, no, we're not going to Canton. Let's go somewhere else. And number two, I would have grabbed you both by the ears and pulled you away from that window of D&E Pizza. For the record, friends don't let friends catch charges, okay? That's all I'm saying. Olivia is here. I just saw her say hello in the chat. Hi, Olivia. If you choose to play in the cesspool of Twitter, which most of you don't, I don't think my audience is on Twitter much, but if you do, you should follow Olivia Lambo on Twitter because she's always got some really great tweets and she explains things in a way that not many other people can. Thank you, On Top, for reminding me of that. RB says, how is this possible? Wow, just wow. Yep. Yeah, it's like we're in the communist country. Iron Rabbit, thanks for being here for a month and for thanking me. YouTube turns, thanks for the 10. Says my mother, Patricia Harper, had her 39th birthday yesterday for the 46th time. For you trolls that can't add, she's 85. She'll be listening to you later today. Can you please give her a shout out? Hi, Patricia Harper. Happy birthday. Happy birthday. Happy 85th birthday. That's amazing. Hope you have a wonderful day. And thank you so much to your child who sent in a super chat so that I would give you a shout out. So, hey, Patricia Harper, thank you so much for watching. We appreciate you so much. Have the happiest of birthdays. The Boiled Frog 61 is here, a.k.a. Bernie Heaven. Says, thanks for fighting for truth and justice. You helped me understand all the legal jargon, helping us focus on what matters. Free Karen Reed. Thank you. Thank you, Bernie, for getting it. Thanks for getting it. Yes, Karen's appearance yesterday on the Glare was emotional. I did screen record it. I was going to show that to you guys later during lunch. It was the first time I've seen her smile, I think, since I met her at her fundraiser. She never smiles in court. There's nothing to really smile about. Who can blame her? But she was smiling yesterday on the on Glare's fundraiser, and it was really nice to see. It was heartwarming. I'll just keep reading to you this buffer zone motion while we wait for court to start. It says here, in connection with the first trial, the Massachusetts State Police issued more than 24 citations for horn violations and other motor vehicle offenses. Can you imagine? Horn honking, tickets. I did. I saw the Proctor interview. It was Courtney Proctor, Michael Proctor's sister. Thanks, Sassy Bartender. Michael Proctor's sister and his wife are both interviewed on the local news. I do not think that was beneficial to them in any way, shape, or form. Kelly Hank Brennan, the prosecutors lost spell check. Hank Brennan's, the prosecutors lost spell check. I get it. Says I'm calling bullshank before it even starts. Grr. Well, let's not start the morning off angry. Let's just get there like a boiled frog. We'll get there, I'm sure. Kelly, if Chloe bit, you must quit, says Kim Jong's septic Hank wants to not only declare war on the Constitution, but now wants to use force against its citizens, demonstrating pathetic. Yup. So moving on from the fact that they say that in connection with the first trial, the MSP issued more than 24 citations for horn violations and other motor vehicle offenses. Oh, here we go. Hear ye, hear ye.
This is before the Honorable. Yea. All persons have any business before the Honorable Beverly Cannone, Justice of the Norfolk Superior Court in Floyd County of Norfolk. Draw near, give your attendance, you shall be heard. Take the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Adam Lally, the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Mr.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Ms. Giannetti. All right.
Sound check. Sound check. Is it low?
So we have a lot to cover, but what I'm going to start with is...
All right, I'm going to turn my volume down. Hold, please. Un momento. Okay, now this is my volume and This is the court volume.
a decision on the Commonwealth's motion to exclude employees of ACA.
Oh, this is going to be important. So is it the volume better? Turn up your volume on your end, and I'm going to I turned my volume down. Good? Better?
So I think I told counsel before that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate.
What?
Concerning the relationship with the ACA witnesses.
What?
They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ACA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ACA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ACA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here.
I need to have a colloquy with Ms. Reed. That means like she's having a conversation with her and advising her outside the presence of defense counsel. She's finding a flagrant misrepresentation of candor to the court, which is an ethical violation. And she finds it to be a deliberate and intentional lack of candor to the court. And she allowed a buffer zone. She allowed an inverted video to be shown in court with zero ramifications. And before she decides what kind of sanction she's going to give the defense, she wants them at sidebar, which they are now. And now we are caught up in real time. And my head really might pop off today. Apparently there is no limit to how biased she can be, says Mudrucker. This is insanity. I have never seen anything like this. She threw Eliza Little under the bus and said it's because of her affidavit in which Ms. Little said that ARCA was not hired and paid for by the defense. And she's saying that you absolutely lied to me. It was deliberate. It was intentional. You misrepresented to the court when you said you didn't hire them. And that is complete, in my opinion, BS, because they paid an invoice after the trial was over. They did not hire ARCA to complete their investigation, their accident reconstruction. ARCA was hired by the feds. We all know that. And now she's seeing them at sidebar so she can give Karen Reed a colloquy before she decides what the spanking is going to be. Is she going to pull the pro hoc vice status of the two California lawyers? Is she going to preclude ARCA from testifying because, you know, it's all about a fair trial for the Commonwealth? And meanwhile, Hank Brennan said in open court that he does not care whether ARCA testifies. He doesn't care. He doesn't care if they testify or not. He welcomes their testimony. This is insane. We are starting off on a really bad foot here, and I'm not going to start screaming just yet, but you can imagine that my head is going to pop off. Jules, could Karen Reed successfully sue the police department? It depends on if she's convicted and if it is found to be a malicious prosecution. She's coming back from the bench. Thank you, Jules. Coming back to the bench.
All right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a matter, Your Honor.
Okay, so because Mr. Giannetti is not pro hoc vice counsel, and Mr. Giannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word. And I need to be able to take counsel at their word.
Maybe you should look at Brennan when you say that.
I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCA witnesses.
Oh, that's good.
Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll move on to
Okay, so much ado about nothing. A public scolding, talking about how candor to the court is so important. You lied to me many times. I think it was deliberate. I think you misrepresented to me. She had a sidebar with Karen. Karen said she wants to keep her lawyers. She is now proclaiming that the defendant's right to a fair trial is the number one important thing, as is candor to the court. Don't do it again. Do not do it again. She threw Ms. Little under the bus, but now she just completely showboated Sweet Caroline. And ARCA is going to be allowed to testify. Alan Jackson and Eliza Little are going to be able to stay on the case because Karen Reed really wants to keep her own lawyers. And now we're moving on. So much ado about nothing other than a public scolding that the media can now use as their soundbite. Thanks for the heart attack, Bev. Moving on.
to Mr. Alessi. You didn't have a chance last time on the motion to exclude the testimony of Dr. Wolf. So I'll hear you on that.
Thank you, Your Honor.
Dr. Wolf is the brain surgeon. We went over that motion. Okay, everyone can breathe now. I'm just going to catch up a little bit to real time. Mrs. O'Keefe and Paul O'Keefe do not look happy.
May it please the court. The proposed testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that he's qualified, prong one, and two, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Daubert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated. In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of death, as opposed to causation, as cause of death, you need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolf is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak specific because he's got to be able to show both, because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolf is qualified to talk about the manner of death. Dr. Wolf invokes a terminology called mechanism of injury. That's the closest he comes to talking about manner of death. And specifically in his report, which is Exhibit A to our motion, the entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, 1 paragraph. And the applicable aspects of that paragraph is he says the following: based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coupe contra coupe mechanism. Mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it. But the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist, and his focus of his practice, by his own words, is based upon the precise invocation of radiation to treat incurable cancer. That's what his specialty is. That's what he currently does. So in terms of qualifications to talk about manner of death, he doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death. He states mechanism of injury, and mechanism of injury is irrelevant. So on qualification prong, Your Honor, it is completely lacking in the record that he is qualified. It's not enough to say you're a neurologist and head of neurology at a certain center. And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scorti-Bello. Dr. Stonebridge didn't even venture into the manner of death at all, didn't comment on it. Dr. Scorti-Bello, who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but speaking to mechanism of injury. So in terms of the paragraph that I was just citing in his finding, he says, based on the findings of his autopsy, it is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, and then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Where is the support that Mr. O'Keefe fell backwards? A neurologist can't determine that is a manner of death. He provides zero bases, zero, for his conclusion that Mr. O'Keefe fell backwards. Where is that? And it's also not in the autopsy. And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a podologist. You need to know something about soil. He doesn't even begin to state how he concluded the ground was frozen. He wasn't there on the date of the incident. So there's no basis for that, but that is part of his opinion and methodology. And now to leaving his lack of qualifications, where is the citation to any study, any acceptance of how Dr. Wolf has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they don't tether the methodology, if you can discern it, to common acceptance or the Dalbert-Lanigan factors. So in terms of both prongs, Dr. Wolf fails because the Commonwealth has not even begun to meet its burden. I would like to also reference what we just received last night, which is an article that was co-authored by Dr. Wolf. And I want to note and this is Fractures of the Classification and Clinical Features. This is 35 years old, and it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury is. So I'm even going to assume for the moment the parlance of Dr. Wolf, mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta study. They went back and looked at a lot of data and information, but it says under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's unknown what the mechanism of injury is with regard to a decedent. And that feeds back into the lack of qualifications of Dr. Wolf, because we're not given one example of where Dr. Wolf, before his report, his one paragraph report on conclusions, of when he's ever done this before. It's not stated that he's ever taken a decedent and determined the manner of death. And I note that this study talks about mechanisms of injury, which scientifically is completely different from manner of death. And what it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury. And that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain that led to the various injuries? So this study doesn't at all, one, support any methodology, number one. It doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolf has explicated in his report. And I will conclude with 2 points. Dr. Wolf says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death.
That's right.
The
It's undetermined.
autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy, and we know from Dalbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolf uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts. It's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death. So in sum, Your Honor, he's not a medical examiner, he's not a forensic pathologist, he has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article, and I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolf from testifying in matters beyond his kin. And in the alternative, we would request an evidentiary hearing, because we and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman. It's the same with other experts where there is no statement of the methodology, as here, there's none. And there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the two prongs of the Dalbert inquiry?
All right. Thank you.
You're
Mr.
all
Brennan?
set. Thank you, Josh, who says if a neurologist is allowed to name a manner of death, then the manner of death on the death certificate should be allowed in, which is undetermined. Well done. I don't think that Brennan submitted any written opposition to this. Not a shock, but I'm looking through the docket. I don't see it, and I don't think we went over it.
Please.
Attorney Alessi mistakenly misstates
Here we go.
Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, And it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon. In addition to his opinion, you can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached. In his internships as a neurosurgeon, he engages in an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury.
His internships? Is he still in his internships? I think he's a older gentleman. I don't think his internships were yesterday. You can see that Mr. Brennan is a little bit dejected because he really, really, really thought that the judge was either going to pull Jackson and Little from the case and or exclude the ARCA witnesses, even though he said he didn't care. But you can tell he cares. And also, he did not oppose this motion in writing, and there's no affidavit from anybody. So everything he says is just not facts or evidence.
Dr. Wolf was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients with head injuries, surgeries. His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries. We can see in his research listed on page 4, he's a principal investigator in THAM treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD in severe head injury, improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. Book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injuries, intracranial pressure, number 2 on his journal articles, initial management of brain and spinal cord injuries, number 9, number 16, which is the document that I produced to counsel last night, listed in his journal articles, number 16, fractures of the clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through, but you can see that he is well published, over 70 articles.
We've got time.
Presentations specifically on fractures, basal type injuries, number 5 on page 13.
That's all he's doing is reading the
Number
CV.
9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on.
There's no evidence as to how his head was injured.
Over 90 references. Lectures and meetings, many of them dealing with head injuries.
Great, he did some conference calls, some Zoom calls.
Over 100 lectures listed for reference, actually over 130, and a number of web publications.
About what?
So this neurosurgeon who has this extraordinary experience is qualified. The
Here come the sirens.
ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead. Dr. Wolf.
Okay, okay. Stop. The stupid meter is off the charts right now. The difference is that a pathologist treats patients that are already dead. How can you treat a patient who's already dead? This has to be rewound for for posterity and for stupidity's sake. Listen to this. Anybody who knows anything about medicine, your head might have popped off already. Listen.
To a pathologist. And diagnosis, ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead. Dr. Wolf treats patients that are in trauma, who some survive and many die. So he is intimately familiar, not just with looking at a deceased in a lab, he's intimately familiar with assessing the injuries after they occur.
I'm sorry.
Diagnosing.
Did he just say he's not, hold on, just in a lab? As if what Dr. Renee Stonebridge does is not as, doesn't take as much as intelligence as what Dr. Wolf does. Wow. He just dissed his own expert, Renee Stonebridge. Hold on.
So he is intimately familiar, not just with looking at a deceased in a lab, he's intimately familiar with assessing the injuries after they occur, diagnosing what the injury is, and an attempt to save the person's life.
But he's
And
not
so he's
diagnosing,
well attuned after.
he's not figuring out how the injury happened, right? Because those people are alive and can either tell him how it happened or they're brought in by EMTs who say this guy was in a car accident. He's not there to diagnose or to figure out or to investigate what happened. He doesn't get it.
There are tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolf's report, although short, it is clear that the injury that was occurred by Mr. O'Keefe was an injury known as counter coup. And I dare say the defense proposed expert, Dr. LaPosada, is not in disagreement with that. To understand counter coup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the brain shifts to the front of the head. That is what the autopsy report shows.
Okay, you know nothing about medicine, and it's obvious, aside from how to pronounce things. But the other issue is he did not examine John O'Keefe's body. He did not examine John O'Keefe's brain. And so, what?
The ground and then the brain shifts to the front of the head. That is what the bat or a punch or hit. There's not enough force. It occurs.
A bat is not enough force. A bat is not enough force, but falling down and hitting your head on the frozen rock hard ground is enough force. How come ice skaters fall all the time on their head without helmets on, and they don't sustain intracranial brain bleeds, and they're falling on ice, not dirt, sir? And you're saying that a bat cannot cause enough force? Okay, yeah, I'm done with this guy. Listen to this again.
Dr. LaPosada is not in disagreement with that. To understand counter coup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it, but this expert does have that expertise.
He just dissed Irene Scordi-Bello. Do you really think that your own medical examiner is now going to come in and be friendly to you after you just said that this guy who didn't even examine John O'Keefe or his brain has more experience and is more learned and a better doctor than your own Commonwealth medical examiner? Oh, dude, you better want what you wish for. Listen to this.
That the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it. But this expert does have that expertise, and it is no different than the pathologist that's proffered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. LaPosada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony. He is intimately familiar with counter coup, having treated tens of thousands of patients, and he understands in counter coup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history. It can't be that his ultimate conclusions of counter coup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth. But we expect to call Dr. Wolf, and I would suggest that he's more than qualified.
All right, thank you. Mr. Alessi, anything final?
Yes, thank you, Your Honor. Thank you.
Please say I don't know what a counter coup is. Because a counter coup is an overthrow of a government
Your
or
Honor,
a coup
I'm going to
d'etat.
note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Daubert factors.
That's right.
And that is the fatal aspect of Dr. Wolf's opinion. It's not stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. I will stipulate, for purposes of this argument only, the cause of death prong. Let's assume, just for purposes, just to focus on manner of death, let's assume hypothetically that Dr. Wolf is qualified to testify about cause of death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death. And that is the distinction I emphasize, Your Honor. Manner of death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction, to limit his testimony to cause of death, not manner of death, because we know, and we cited the Graham article, which is attached to our motion, which specifies who is qualified to talk about manner of death. Because what does manner of death do? It takes into account all the circumstances surrounding it, the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV, there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship in pathology. That does not qualify him to engage in manner of death 40 years later without any experience from that internship all the way until 2025.
It was 40 years ago. There's your answer.
Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did, because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolf, none of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolf's qualifications and what his practice has been. And Attorney Brennan concedes it by his own words. He said cause of injury. And again, for purposes of this argument only, I will concede cause of injury. But manner of death was not addressed by Attorney Brennan. It's not addressed in any of the qualifications of Dr. Wolf, and it's not addressed in terms of the one paragraph that we have. And for something as significant as this, one paragraph that doesn't address common acceptance, methodology, Dalbert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge Your Honor to find that he is not qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here. But in terms of all of the record that's presented, including the CV, etc., there's not one instance where we see that Dr. Wolf has even approached determining cause of death or manner of death at all. So I don't see where there's a record to find him being able to do that for the first time in charges of this nature. Thank you.
Do you want to respond at all, Mr. Brennan?
Yeah, could you get up and say contra coup? Contra coup. It's not counter coup. Counter coup is a.
At some point, arguments become semantical and theoretical, but not practical.
With you always.
This doctor has treated thousands and thousands of patients, many, unfortunately, which have died.
But they were alive when
And
he treated
as a
them.
neurosurgeon, engaging in the operations and the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them. So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades of experience, seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alessi, but that is so unnecessary because it's obvious. Thank you.
Okay. Thank you.
Okay. He's not qualified.
All right, so we have a series of motions in limine.
So we're just going to
I'm
just
going
move
to
on.
Start with
Under advisement.
defendant's motion to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear the
course there
defense on
is.
this motion.
Thank you, Your Honor, if I may. This is a relatively straightforward and relatively short.
I have a question. Did you use this last time? It
We
looks
attempted-
like,
We attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence. and
did
presented.
she adopt it?
She
Was
did.
there, okay.
She did indicate, and that's part of my argument, Your Honor, which
So I'll go ahead, I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial. No dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will
So
recall.
let me just have, so you're just trying to use it as a chalk, not an exhibit?
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's a very complicated.
So let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
It'd be a partial objection to a chalk, some of the labeling. I have less concern of a chalk as I do.
Here's the difference between a chalk and exhibit and an exhibit. A chalk is shown to the jury during the trial, and an exhibit can be brought back with them when they're deliberating. Christina Hanley was an MSP. She was the one who examined the glass, and there were 4 different types of glass found. The glass on the bumper did not match the glass on the cocktail glass, right, you guys? We're collaborative. You can correct me if I'm wrong.
Do an exhibit.
I mean, so we can take it in 2 steps. I certainly don't need to decide now whether it's admissible, and I couldn't. But what's the nature? Is this something?
The court will call this deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass, there were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last time,
No,
right?
this is
That was
more
tail
to the
light.
glass in the bumper.
Okay.
Oh, for the love of the traveling Mary. This judge does not know this case. The 47 pieces was the tail light. This motion has to do with the glass. 4 different sources of glass were found at the scene. The glass on the bumper does not match the cocktail glass that was found with the leaf blower.
The glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
These were a bunch of pieces of glass that were originally that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple sources and different and distinct between and among each other. We reduced the very complex, the court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very difficult. It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she.
And it's even difficult for your honor to follow because you thought I was talking about taillight pieces, which are not glass, they're polycarbonate. So don't you think, Your Honor, since you can't even understand what I'm talking about, that the jury should be able to understand what I'm talking about and what the witness is talking about?
She tried to maintain her accuracy. So
Do you have the day of her testimony?
Oh gosh.
Ms. Little, do you have that transcript pulled up?
Yes, one moment.
So obviously, I remember her testifying. I remember seeing this previously.
I've got it. June 5th, 2024, Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, and I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her on the witness stand, and she did adopt it. And she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear logic to the evidence, what matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Hanley's testimony would be apropos, and then we'll ask for its submission at the right time.
All right. What's the objection, Mr. Brennan?
She's like, really? What do you need to object to?
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there, but also it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect.
I'm sorry, why shouldn't they know which troopers collected which pieces of glass? Do we really want to keep the jury in the dark? Remember, they have to rely on their notes. They're not allowed to have readbacks of testimony, and they have to rely on their notes. Why can't we give them an exhibit or a chart to make things easier for them to remember? Seems like if we want to get to the truth, we should give the jury the proper information. But Mr. Brennan doesn't want them to know which troopers found which pieces of glass. Okay.
Is going to be a issue in the next case. And I say that because we learned last night for the first time on a public airing of an episode that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car.
Yep.
Now that is the first time we've had any statements from Ms. Reed suggesting that. And also there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face.
Yep. She said that too.
Never heard that before.
I watched
we have
it.
This evolving or new testimony or statement, rather, statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful, but I don't have confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important, but looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
Mm-hmm. I want to talk about this for a second because last night in the documentary, Karen did say, John took my vodka soda drink out of the center console when he left the car. I also want to point out to you that she said in her documentary, they did, or she said, where did she say? She said it on Glara's show last night. The director for this documentary took like 400 to 500 hours of footage, or 300 to 400, something like that. A lot of footage. I would love to see the outtakes from that footage. You know he's going to ask for them. You know that's going to be a reason because now it's 500 hours of footage or 400 hours. He's going to need an adjournment on April 1st because he's got to go through 400 hours of outtakes of cutting room floor stuff. I will bet you anything that before she said he took my vodka soda glass out of the center console, she said he took my full vodka soda drink that I did not drink out of the waterfall and brought it in the car with him. And then he took it with him when he got out of the car. She also did say last night on the documentary that when she went over to him, when she first found him, that she took a piece of glass off of his nose and then it started bleeding, right? You can refresh my recollection on that. And also that there was a cut next to his eye that were bleeding. And Magnolia Gypsy says it doesn't matter. The Discovery ID people are not in Massachusetts. He won't get them. But again, more sound bites for the media.
All right, so Mr. Jackson, what I'm going to do is just hold off and see where the evidence is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. I need to hear more of the evidence again.
I understand.
And I'm going to read the transcript, so that will help me with
I think
this.
it makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of seize the day. It's Ms. Hanley. So I do think that if the court would keep an open mind,
Sure.
Ms. Hanley testifies, then that would be the appropriate sign.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Sure.
I'm open to working with them if there's something they want to explain.
All right, great, thank you. All right, so no action taken on paper 558. So one question, the next motion I have is defendant's motion to exclude irrelevant, inadmissible and prejudicial prior bad character and propensity evidence. The Commonwealth has a
Aruba.
sort of maybe a similar one that I'm not sure. The Commonwealth's motion eliminate to admit the victim's out-of-court statement relating to his state of mind. So the Commonwealth's Bins and Qualls motion, does that address the Aruba witnesses?
Mm-mm.
I'm just wondering if they're hand in hand.
Oh, well, because
So,
maybe John O'Keefe said something to the Aruba
The
witnesses about
paper
his
number on the
relationship with Karen.
Commonwealth is 585. It's got your 11 on it, though. So the defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with the, let's just say the Aruba
Yeah, what's the number? Could you give us the number?
witnesses. I don't, Marietta Sullivan, Laura Sullivan.
The Sullivan Sisters.
Does this, Ms. Giannetti, I think this was one filed by you, maybe it wasn't. Does this include the children as well?
This does not. This is
Okay.
limited, this argument will be limited to the, we'll call it the Aruba incident.
Okay. All right. So given that, that might not include the Commonwealth's number 11, the Qualls, Bins, the defendant's statement, the victim's state of mind as it goes to the defendant's knowledge and ability, likelihood to act on that state of mind.
The defendant,
So I just want,
I didn't mean to interrupt, Mr. Brennan. Do you want to?
so I just want to know if that is part of the Aruba one.
Okay.
No.
so our statements relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We
Okay.
do not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right
What?
if the defense opens the door, then.
So
we
he's
may
not calling the
proceed
Sullivan
with our
Sisters?
case in chief. We don't intend to introduce any evidence from the Aruba event.
Okay.
Shortest
There we go.
argument ever.
All right. All right. So Mr. Brennan, you can have a seat again and we'll go through the defendant's one. That's very helpful. So I will endorse.
He did say though, on our case in chief. So if they bring up Aruba, he will bring the Sullivan Sisters in on rebuttal. But I think what he just said is we do not intend to introduce any evidence on Aruba. So he's not calling the Sullivan Sisters. He said it in open court, which means that neither one of them should be able to testify about anything because that's all they testified about. Marietta said Karen sucks. Good. Nobody needs to hear that again.
It as Commonwealth does not intend to introduce in its case in chief. If that changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood. Thank
All
you.
right.
Of course it's going to change.
All right, so that was 559.
I don't believe him, do you?
The defendant's motion eliminate for review. Is the Commonwealth seeking a view as well?
We did not move for a view, but we do not object if the defense wants a view.
Okay. So who's going to argue this for the defendant?
I am, Your Honor.
Okay, so what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
Your Honor, the
Why are
defense
we
is
hearing her if there's
requesting
no
that it exercise
objection?
its
If
broad-
there's no objection, why does she need to? Did I miss something? Didn't he just say we have no objection? if he objected to Karen Reed going on The View, wouldn't he have said he objected to Karen Reed going on The View? But she can't just grant it with no opposition. She's got to hear argument. Okay, hold on. I again, upside down, inside out matrix of Norfolk County.
We did not move for a view, but we do not object if the defense wants a view.
We don't object.
So who's going to argue this for the defendant?
Oh,
I am, Your Honor.
love the
Okay.
traveling Mary.
So what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view.
Okay.
Okay, but let's talk about your client attending it.
Yes, Your Honor, there was a request in there for Ms. Reed to attend. That is something that's allowed under the law.
Mhm.
If
How do you propose that's done?
if it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus. If the court can make that accommodation, we would appreciate it.
She can
But
go
the
with her
most important thing
attorneys.
In this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
Why can't she go in a car with her attorneys? The attorneys are not going to go on the bus with the jurors.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay,
Where
what are
should
you
be?
proposing for that?
Sallyport?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate.
So you
it's
had
not
no objection, but now you have an
sitting
objection?
In front of that home in totally different lighting conditions, timing conditions, and I think it can be misleading.
All right, I need some suggestions.
You know, it's
Why don't
misleading.
we,
An inverted Sallyport video. Why don't you let them go to the Sallyport to see it so that they can see all the cameras that are all around there? Actually, you know what? That's a better idea. Mr. Lally was the one who insisted that the vehicle be at 34 Fairview last time during the first persecution when the jury went on the view. But now, Mr. Brennan, who had no objection, now does not want the vehicle at 34 Fairview because it's not going to be dark out. Good. Put it in the Sallyport. Great idea.
table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance.
You're supposed to set up security and block off the street.
Is fine. I think, would counsel plan on being in the car with her?
That would be fine, Your Honor.
Or, so I need some proposal. So I need more information from both. So, Mr. Brennan, I'd like you to come up with a proposal about viewing the car a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place. If that's what we decide, we may have to do it all at once.
I do
So-
think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Let's get a snow machine. Let's get a snow machine and do the view at midnight with the SUV there. Great ideas, you guys.
Okay. All right. So let's try and figure out some of the particulars. I would like to have Ms. Reed be able to attend. So let's figure out some
Wow.
particulars.
Shocker.
All right. So defendant's motion eliminate to exclude certain witnesses before and after
Yes,
testimony.
please.
That's 462. And I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing?
They want to keep
562. Did I say
the
4?
McCabes
Sorry.
and the Alberts
562
out of the courtroom
and
forever.
576. So Ms. Little?
Thank you, Your Honor. I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes,
Focus on that part of your motion.
They
Yes, Your
intimidated the
Honor.
jury.
We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family. At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a deliberating juror?
I don't know.
Okay.
She was, or he or she
doesn't
was
matter.
anonymous.
Okay.
Does it?
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with their.
All right. So obviously is not something, it should be in a motion. Okay. If you've got an agreement that each other's experts can be in the courtroom during the testimony.
Okay, it needs to be an emotion. Why is it that Hank Brennan can get up and say whatever the duck he wants to say, whenever he wants to say it? It's never in papers. It's never in a motion. But when the defense tries to say, we agree, we're in agreement, we just want the experts to be allowed to listen to other experts, which is commonly done. You don't need a court order or the judge to allow that. It is something that is very commonly done. But according to this judge, now she's going to have to put it in writing, or you're going to have to get Hank to agree. Great.
That's one thing, but it's not obvious that they're permitted. Okay.
I just wanted to make sure that that would be excluded from the order that the Commonwealth proposed.
In every other jurisdiction, it's
Because
obvious.
the way that they wrote it, it says all witnesses. And I'm guessing that, I won't speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
All right. So you all need to talk. All right. And
Good
if
luck.
there's a disagreement, you need to put it in writing.
Good luck with that.
Generally, experts are permitted, but it's not a given. Okay. All right, Mr. Brennan, do you want to weigh in on people being able to? I'm concerned about after the evidence is closed.
Why? Because your boss says that he wants them in there for closings?
I think it's
Maybe,
unfortunate
my
that
opinion.
not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets. They name Higgins, Albert, they invoke those names, they characterize third-party culprit, and they suggest that some anonymous person was uncomfortable.
Some anonymous juror?
It seems as though
You don't mind if the jury is uncomfortable? It's very cool with you if the jury is uncomfortable, Mr. Brennan? Because you want those people in court staring the jury down because you know how intimidating they are. Wow. Wow, it's a juror.
the presentation has a deliberate point. The promote a cause, but it doesn't have any sense of balance or fairness whatsoever.
Pot me kettle.
Witnesses, all witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion.
Grace?
Ms. Reed has 3 potential family members who are potential witnesses for the government.
Yeah, right.
And certainly I would have a right to try to ask the court or insist that they should be sequestered.
You're never going to call
But
them,
I
sir.
specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in the courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful.
It's not in the benefit of the government for Karen's family to be there, but it's graceful. You're going to show grace. When we read at least one motion yesterday where you blatantly accuse defense attorneys again of ethical violations, and you are calling yourself, you are the furthest thing from graceful that I think I've ever met in a courtroom or seen on TV. He is so self-unaware that it's mind-numbing. We're going to have to watch this again at lunch because this is some of the finest gaslighting that you may have ever seen. It is a master class in gaslighting. He's being graceful. It is not fair to the Commonwealth. Listen.
But I've specifically asked that they not be sequestered. I think that an accused
Her family.
has a strong need to have family support in the courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rest and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea that the
Justness.
targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may or even if they do become witnesses.
Wait, hold on a second. Hold on. He says that he wants them to be in the courtroom during closings, the McCabes and the Alberts. Hold on a second.
All as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rest and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness,
They're not family.
in courtesy. And so I ask you to deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may or even if they do become witnesses.
Okay, they're two different motions, you guys.
Your Honor, if I could address one issue.
Sure.
There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective
Okay.
order, but I would like to make a record.
Excellent. Make a record. You go, girl. So there are two different motions. There's one motion to keep the McCabes and the Alberts out of the courtroom even after they testify, before and after they testify. And there is another motion to allow, that the Commonwealth made, to allow Karen's family and the O'Keefe family to remain in the courtroom, I think before and after they testify.
But I'll take a closer look at both of these and have something later.
Later today. And Higgins, yes. Albert, McCabe's, and Higgins.
All right, so Ms. Giannetti, I think this next one might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
Mm-hmm.
That's also mine, Your Honor.
Okay,
I believe the Commonwealth has indicated that they will agree to that.
Wow.
okay.
Shocker. A consent motion.
All right, so paper 565, allowed by agreement. So 566, defendant's motion for panel voir dire. Who's arguing that?
That's me, Your Honor. Thank
Okay,
you.
so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on panel voir dire for me?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime, and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights to.
Okay, we covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys, would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit through an extensive trial, a complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is at least a modicum of panel discussion between and among the jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to impanel a fairer and more comprehensive jury.
Okay, it's the Commonwealth's position.
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument.
I'm sorry, but I'd just like to point out to you, Mr. Brennan, that Ms. Reed is facing life in prison on that second-degree murder charge, life in prison. So do you think you could take a little extra time in jury selection and let the lawyers speak to the jurors instead of forcing them to fill out a questionnaire and then relying that their answers are going to be 100% candid and truthful? Do you think you could spend a little extra time, maybe a day or so? Or is that taking too much time out of your real busy schedule? Because you're going to need to watch, like, I don't know, if you can even get the outtakes from that Discovery ID documentary, hundreds of hours of footage. I thought it was crap, by the way. We'll get into that later.
In a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides. And I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or follow-up that's reasonable and necessary. And I understand that that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from, is panel voir dire consistently. It's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right?
Yeah, it was on
and it's
Discovery ID. It
continuing.
sucked.
It's because of that. I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow. So I need a list of witnesses from the defense.
They filed it.
You to fill out a report so that we know exactly what.
Here's the thing. They filed it. Jim didn't scan it into the system because it was in the system the other day when I looked. And then when we went to find it, it wasn't there. So please do not in open court accuse them of not submitting their witness list. Hello, Jim, Clerk Jim. Tell the judge where the witness list is. Or as I called it for the Commonwealth, the witless list. Just a reminder, gentle reminder, please hit the like button while you're here. Helps the algorithm.
Is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire, but I want you to agree to it. And if you can't, I need that. I need that by the end of today. If you're not going to agree to it, have you proposed a questionnaire? Have both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we can act on to start with.
So let's do that. And what Mr. Brennan's new to the case, what I make.
Too bad.
When I need it in questionnaires, it has to be one page, both sides, no more than one page.
No more than one page questionnaire?
Tomorrow, I would like to talk about the particulars of it. We have
use 4-point type.
A huge amount of jurors coming in, and I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case, unfortunately, I think because of all the publicity.
Because of publicity.
And we'll do extensive voir dire at sidebar and the questionnaire.
Like that doesn't take a long time.
566 then is denied because it's requesting panel voir dire. 567, defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand.
It's obvious.
So
that's an obvious one, Judge.
Is there an objection to that, Mr. Brennan?
There's not. I believe that rule should apply to both sides. I have no objection.
Okay.
Oh, shocker.
Mr. Jackson, do you agree it applies to both sides? Ms. Little?
Thank you.
Okay. All right, so that, Mr. Clerk, 567 allowed as to both sides.
Shocker.
$570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses.
Yeah, let's hear that one.
All right.
Thank you, Your Honor. The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties.
Okay, if you're not listening, come back and listen because this motion was impounded and we did not get to review it. So we are going to learn a lot of things during the argument of this motion that we were not allowed to see in the papers. So come back to well, you don't have to come back to your screen, but you can just listen. And here we go. Docket number 570. This is the defense motion. Eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses.
Both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, "You know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it." In some way, shape, form, or fashion. She outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others, consider an unjust prosecution of an innocent person for a crime that she did not commit. There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable
I
cause
understand
standard,
that.
right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And
A grand jury can indict a ham sandwich, according to Chief Justice of New York State Saul Wackler. That grand jury did not indict the ham sandwich of Aiden Carney and Karen Reed for witness intimidation, Your Honor. You know that. Come on. Silly. Don't be silly. Don't insult our intelligence, please.
that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery. when we finally found out that a no bill was issued indicating that Miss Reed.
When was that no bill issued?
You said when or where?
When?
When? I want to say March 23rd, March 27th is what I'm being told.
2024?
It was late March, before the first trial. And they knew this, and they didn't provide what I believed, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then
Stop
I have
interrupting
a very
him.
clear memory of you opening the door with
Bullshit.
Jennifer McCabe, and it came in through there.
So the court did make that ruling that ultimately, if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be opened very easily.
Read the transcript.
It was a swinging door, Your Honor.
I have several times.
Oh,
In
He's
any
like-
event, I believe that the court should make the exact same.
AJ's like, I'm safe now because at the beginning of the day, she already said she wasn't going to pull my pro hoc status. So game on, Your Honor. That door was on a swinging hinge. Listen to that again. He's coming back. He's got his fire back, and I'm here for it, and I love it. And he's smooth as butter.
It was on some very. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be opened very easily.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to Miss Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time.
Right.
What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. In any event, I think the court understands what our concern is with regard to this subject matter. We don't want a free-for-all of people, one person after another walking into court and basically lambasting the defense for all intents and purposes about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan.
We do have a WD-40 emoji, and it was because there was a really squeaky door during one of the trials that we watched. But here we go. Lubricant has entered the chat, so it now becomes
I
appropriate
can
again.
appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me.
I know you are, but what
Is
am I?
beyond me.
It's
It
beyond
wasn't
you.
just last night when
What? Okay, now he's going to talk about last night. He's going to talk about the documentary. Hang on. Maloney's Law says Jackson asked Jen if she and Mrs. Proctor talked about the case, and Jen launched into a speech about being harassed. Yep. You know, we were just two mothers who were being harassed, and so we bonded over that. Yep. And he's talking about somebody launching into a speech for the media. I got to take that to the beginning of his ridiculousness. Hold on. Here we go. Pot, meat kettle. I know you are, but what am I? Nanny, nanny, poo poo. Boss baby Brennan.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me, It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Miss Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And
she's allowed to do that.
would have to choose to be oblivious.
She did. She said, I spoke with him nearly every day because I began to not trust the intermediary that I had. And my lawyers told me that it was okay to share with Aiden Carney the things that were public, the documents that were public. It was okay. But now he's going to twist it into something nefarious. Nefarious because he likes to say nefarious. Just like he called it a counter coup. What we know, the brain injury, the TBI, is called a contra coup. He called it a counter coup, almost like that attorney who said carotid artery instead of carotid artery, and we cringed every time. Take that back a second. For those of you who didn't see the documentary.
Where Miss Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity
Please focus on
to hear
Turtleboy's
the
face.
conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept,
Inept?
fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably.
Wait, we have a motion later today in another courtroom? What is he talking about? What is he talking about? Aiden Carney has a hearing at noon in Stoughton. Why is he saying we? Are you involved in the prosecution of Aiden Carney? Or we as in the Norfolk County District Attorney's Office? And I don't think that it's a motion today. I think it's an arraignment at noon, right? Wow, he's really trying to get AJ in trouble again. Yes, he is pissed off. He is pissed off that he wasn't kicked off the case this morning. And he's trying, calling them inept. Let's listen to the more accusations. Hold on. We have a motion later on this afternoon in another courtroom. Are you going to Stoughton for noon, Hank? Boss baby? To make a public record that is so egregious? Hold on, listen. Over a dozen indictments. He's not been convicted of anything. Again, ham sandwich, intimidating witnesses, selective prosecution. And if you think that Michael Proctor and Yuri Buchanan are afraid of Aiden Carney, come on, dude, really?
In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics
Gretchen Voss.
used by the defense in the dissemination, not just of public information.
Tactics.
So to try to make a public record that is so grossly, not only inept,
You're gross.
but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum.
We all
She didn't
saw it.
drag herself into this case. She was dragged into it. And to suggest
You know who else was dragged? John O'Keefe was dragged, maybe carried, into the front yard of 34 Fairview. So when you get up there and you talk about inept and fraudulent, perhaps you should hearken back to the hearing where you held up those papers and you waved them around in open court and you accused the defense of hiding them from you. And you told the judge that you had to obtain them from the U.S. Attorney's Office. And you lied in your entire monologue leading up to it, when the truth was the defense gave those papers to you. You started this. You're inept. You're fraudulent. And everyone can see it, except for you, because you have zero self-awareness. Thank you for coming to my TED Talk. Moving on.
they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative,
Pleases
is
them.
something I can't just sit by and listen to.
No, you can't, because you're defending the McCabes and the Alberts.
The
Of course you can't.
Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done.
On the butt.
The witnesses who harassed at the family events. That didn't happen. And so if the issue is, what is the
There was some video of either, I can't remember if it was Yannetti or Jackson patting Aiden Carney on the butt, but you know, bring it in, Darvo. Yeah.
threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect.
In the defense of the
And we'll be
McCabes.
prepared. I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief,
Oh.
and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
In all of that, he agrees. Now he agrees that it shouldn't come in. Here's the thing. During the first trial or before the first trial, the judge said, well, you know, if it comes in organically, I'll let it in. I don't think she said if they open the door. I think what she said was if it comes in organically. And you can bet your bottom dollar that Miss Lally and Ms. McLaughlin, because I'm not so sure that she's so innocent in all of this and that she wasn't involved in prepping these witnesses with their impeachment testimony and other things. And I'm pretty sure that they were probably told, well, also we know they had viewing parties, so they probably watched it on TV just like we did during the hearing when they were told that if it comes up organically, they can talk about it. Were they prepped to have it come in organically, or did they just watch the hearing that we watched and they, you know, made a timeline, planned their testimony? They all rehearsed. Colin left at 12:10. 12:10 came up a lot during the first trial, and you know it was rehearsed. And in the end, he agrees it shouldn't come in, but he had to get up there on his soapbox and make his speech in defense of the McCabes. That's all that was. Our little circle. Yep, our little circle. I didn't know that.
Your Honor, if I may very briefly.
Sure, just give me 1 second. I want to take one note, okay?
Of course.
Take one note, take all the notes.
All right, go ahead, Mr.
I
Jackson.
just wonder if where this
That's a great question.
ire and these invectives from Mr. Brennan come from.
Mm-hmm.
He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements.
Yes, he did.
Was he listening? I didn't bash a witness.
Good.
I didn't attack a witness.
Stick
I didn't
with
make any
yourself.
fraudulent statements. The Commonwealth made their best effort to tether Miss Reed to Aidan Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said at the lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation,
Okay, if you're not looking at your screen, come back and look at your screen. My freeze game is on point today because not only does the cameraman have
witness
a shot with Aidan Kearney's face, it's got Nathan Reed's face and Alan Jackson all in the same frame. Take it back a second. Excellent work to whoever the pool camera person is today.
I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness and the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very zealously and robustly. But let's keep it professional. I didn't stand up here and attack a witness, or what did he say, bash witnesses, use this as an opportunity to bash people. But we could calm the drama down just a little bit and probably get a little further. All we're asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief. And we will be very mindful of what would conceivably open a door to this kind of testimony. And I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close to that. We'll ask the court's guidance by coming to sidebar. And I think that could resolve the issue.
Okay. Thank you. I'm going to look at this a little more closely.
Oh, even though Brennan agreed, she's going to look at it more closely.
All right, the next one is paper 571, and the Commonwealth's corresponding is your number 12, our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth make their argument for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to
Okay.
answer your question, the defense preference would be for the Commonwealth to go first. and we
right.
would respond, including with regard to the motion.
Yes,
Okay.
Alessi.
So, Mr. Brennan, our paper 386, your number 12.
No, 586, sweetie. It's 586. This is important. This is to keep the blood alcohol content extrapolation out. Commonwealth wants it in. Alessi
Your Honor,
said,
paper number 12 seeks to admit the results of the
Alessi said Commonwealth should go first, and he's right. Let them argue why it should come in, and then Alessi will get up because he's great on his feet, and he will refute. And he will say why the extrapolation evidence should not be allowed in. This is his wheelhouse. This is what he does. This is his specialty, and I'm here for it. We're a little bit behind. We did not skip over the motion to dismiss. It's already been argued. She has not come to a decision. That was argued a couple of hearings ago. So no, whoever said that, you did not miss it. That is not for today. Today is motions in limine.
defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion in retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth v. Hallinan, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right. Now I'll hear you, Mr. Alessi.
Thank you, Your Honor.
It's not much of an argument.
Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable, and here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up in ipsy dixit in saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter.
Ipsy Dixit is our new favorite Latin phrase. It means because he said so, and it has entered the chat. Ipsy Dixit. Let's hear it again and how he uses it. We love Ipsy Dixit. We're going to make a mug.
Reliable when there is a lack of the information of the Dixit for to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up in ipsy dixit in saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states 2 paragraphs under the chart with an asterisk. The ethanol result used in this serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B, in terms of changing that conclusion in that statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas, chromatography, or enzymatic, and we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
All right.
It should be excluded.
Their own witnesses
You wanna
admitted it.
respond, Mr. Brennan?
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, how it was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Give the judge more work.
Okay,
May I just respond briefly?
sure.
Thank you, Hunter. Your Honor has often said that this is a new trial. The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in, assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever reference that as curative of what they said for lack of accreditation.
Right.
And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
That's right. And you just told Ms. Little you couldn't consider something that
I
wasn't
think
in
we
her
have time
papers.
for one last motion
By the way.
before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history.
And I think
Who's
that has to do with
arguing that for
Richard
the
Green
defense?
and some
Is
stuff
there
that trolls
no
on
objection
Twitter
to
found
this?
against
This is
him.
regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay.
Oh,
All
he's
right,
not
so
going to
this
get it in.
motion is allowed.
He's not going to use it. Imagine that.
That's 574 is allowed, Mr. Clerk. All right, so what I'll do is I'll see counsel at sidebar regarding scheduling.
Oh, the Twitter trolls are going to be so upset about it because they found all of this information regarding a bar fight that apparently Richard Green was involved in many years ago after his father died. And they tried to, they put his mugshot up all over the cesspool of Twitter and they thought they uncovered some big smoking gun for the Commonwealth. And, Hank Brennan just admitted he's not even going to use it. So that motion was allowed. Now we're a little bit behind, so we're going to fast forward a little bit. Hank is so graceful. Isn't he so graceful? He likes to talk about how graceful he is. He did talk about it. Fast forwarding to real time before the morning break, the morning recess.
All rise for the court, please.
You are muted.
Okay, so what are we doing? Are we just taking a little break?
We'll be recessed 15 minutes.
15-minute recess. Okay, let's see how far behind we are. Oh, we might be able to skip right through the break. Look at this, you guys, we're catching up. Maybe not, but the fan is back. Only fans all the time. You guys missed that fan? I'm going to make it smaller because it makes me nauseous. All right. Back to the chat. Well, it's been quite an exciting morning. We started off with a near heart attack when the judge addressed her grave concerns and found that the defense had made material misrepresentations in their withholding that they paid ARCA in July of 2024. And we thought she was 5 seconds away from taking away Alan Jackson and Elizabeth Little from the defense team, but she had a little colloquy with Karen Reed and her attorneys at sidebar outside the earshot of the Commonwealth, and she allowed them to remain on the case despite what she called their deliberate lack of candor to the court. And she threw Elizabeth Little on the bus for her drafting the affidavit dated February 26th of 2025, in which Ms. Little said that ARCA was not hired and paid for by the defendant. She found that to be a material misrepresentation and a flagrant Rule 14 violation. But because she is so interested in a fair trial for Karen Reed, she said ARCA will be allowed to testify and Mr. Jackson and Ms. Little will be allowed to stay on the case because Karen told her at sidebar she really wants them as her attorneys. Tracy Walker is here. She gifted 10 memberships. I'm sorry I'm so far behind on this. That was at 9:09 a.m. It's now 11:14. Thank you so much, Tracy. You're such a kind and generous contributor to the channel. And another 10 memberships by Ms. Jules from I think it's Florida. Thank you so much for gifting 10 membership, each of you. You're so very kind and generous. Bez Bangs says the only way she can actually point to the trial in the way she needs it to go. She's despicable. She's going to throw AJ and Liza off and not allow Arca. Well, luckily that didn't happen. But thank you, Bev's Bangs, for your very amusing username. Ms. Jules from Florida said that is just disgusting. Thank you for your 10. Laura M says, I can't believe the judge said nothing should be distorted. Yeah, inverted video much? Thanks, Laura M. Eric Clark, thanks for the 20, said, what an absolute unmitigated joke. And this was back at 9:19. This fool's on video letting the Commonwealth lie to her repeatedly, saying nothing but one irrelevant statement from defense attorney Little. I'll put a like on this and then I'm tapping out. Don't tap out, Eric. I hope you stuck in because it gets better. It gets better. Motions in CPA, thanks for the 10. Judge, I'm sending you my bill for a heart attack. PayPal or Venmo works, right? Thank you. Melanie Little's Magic 8 Ball is here. Oh, yes, I have a Magic 8 Ball. And you keep changing your username. I notice your picture stays the same, but your username changes and they're all very funny. Thanks for your 20. Says, I hope the defense team has seen that they're not playing nice and start calling Hank out on all of the lies that he continues to tell on the floor of the court. They're going all out to convict her. This is a travesty. It is. I agree with you. Ms. Jules came in upbeat and Bev just broke me. That was at 9:25. So I hope that you're returning to your upbeat status. Heather says, how dare she speak down to the dream team, but let Brennan whine and spew lies and spin, even though it turned out to be nothing. I'm fuming. A lot of people feel that way. Al dente, tuning in from Canada. Bev is not faithful to the law, can't stop being a lawyer or a compliance officer. Repeated intemperance. She's violated several judicial ethics, in my opinion. Oh, Vanessa, thank you so much for your very generous $50 super chat. Says, will Bev publicly spank Hank for his blatant misrepresentations to the court? This is absolutely disgusting behavior by this judge, the prosecutor, and all police agencies involved in this witch hunt of a factually innocent woman. This is so, there's so many parallels between this case and the Salem witch trials. Really, it's uncanny, isn't it? And then we saw again, this super chat came in earlier before 9:30. We saw again how Brennan stood up in open court and accused Alan Jackson of saying things and bashing witnesses and flagrant lies and blatant misrepresentations. And we heard it too. And no, he didn't. And then Alan Jackson thankfully got up and corrected the record. But still, no public spanking for Mr. Brennan ever. Thank you, Vanessa, for your super chat. Letteros by Betero, thanks for the 20. This has been a planned, targeted attack on the defense by Bev and Hank, doing what they can to make the defense look like unethical liars to media and potential jurors. No worries about inverted videos, Brady, or Hank's lies. Yeah. And still no decision on the motion to dismiss. We're still waiting on that. Mickey is here and says, me states manner of death undetermined, regardless of what corrupt proctor requested. Yep. Oh, the ME states. Yeah, not me. The ME. Yes. Well, should have been allowed to note that part. Yep. Thanks, Mickey, for your super chat. Bill Frittenberg. Spanky looks like someone forgot it was the day to present his book report. Thanks, Bill, for your super chat. And Melanie Little's Magic 8 Ball with a $50 super chat. Thank you so much. Does it benefit the defense in event of later appeal that Hank does not file an affidavit? It may. It may, because a lot of these motions that she's deciding in his favor, some of them are facially, in my opinion, insufficient or deficient without an affidavit. It's the way we do it in New York, but apparently this may not be the way they do it in Massachusetts. So we'll see. I ask because he continues and Bev allows him to continue doing it. I'm repelled at the activities by the Commonwealth. I'm sure that you also are in a different jurisdiction. And if you are an attorney in a different jurisdiction that requires affidavits, our heads are popping off. Thank you very much for your very generous super chat. Get love, give love. Says good morning. Is it me or is Bev dataless is Brennan Icarus because she allowed him to fly near the sun and he melted as she made her decision? I think he really, really, really thought he was going to win that based on her opening monologue. And I think, yeah, that was a win for the defense and a big loss for him. Even though he had no problem with Arca testifying, he said that he welcomes their testimony. He welcomes them. Yet He had concerns, grave, and she had grave concerns. And just want to make sure we're on real time here. And Arca's going to be allowed to testify. Maybe Karen Reed will get somewhat of a fair trial, although that will remain to be seen. Here, Suze is here, and she's a grandma. Who's going to tell him that he's making a case for Dr. Russell? Dr. Wolf cannot even attest as to the cause of death. My neurosurgeon would be laughing. Thank you, Grandma Suze, for your super chat. Audrey's here and says any doctor can declare cause of death. The difference is you have to have them as your patient, and the manner is natural. Otherwise, we opine but defer to the ME. Audrey, I imagine that when you say we, that means that you too are a medical doctor. And yes, if it is a natural cause of death or manner of death, I should say, a medical doctor can opine as to that. However, you defer to the medical examiner. Thank you, Audrey, for chiming in. It's good to have a doctor in the chat. Mary Rothman says, Hank, you're not prepared. A pathologist is the only one qualified to determine cause of death. Sit down. Thanks, Mary Rothman, for your 10. Alessi, how much you got? Oh, I get it. Thanks for 5. Perhaps Bev had a bone to pick with Jackson ever since the Spacey trial. She couldn't make the ferry because of all the media. Well done. She didn't sit on the Spacey trial, though, did she? Oh, because you're saying the Spacey, wasn't that in Cape Cod? The Spacey trial? And there was too much media. She couldn't make the ferry. Got it. I'm picking up what you're laying down there. Thanks for the super chat. Melanie Peterson. Melanie is a rock. Thanks for your 20. How can she make these choices with good conscience? She's so very unethical. She makes all the good judges look bad. So angry. I may have to leave work. Don't leave work. Don't let this woman ruin your day. It's a good time to point out that the opinions of my viewers are not always my opinions. And they are entitled to their opinions. And sometimes we do have the same opinions. Thanks for your super chat. Ms. Jules, it is coup contra coup, dude. It's contra coup. It's contra coup. He was calling it counter coup, which actually is a thing. And it's like a coup d'etat. But a contra coup is a traumatic brain injury that he said cannot be caused from a bat. But, Audrey, if you're a medical doctor, can you opine on that? Can a contra coup actually be caused by a bat? Because my understanding is that it is. It's a brain shift caused by any blow, perhaps to the skull. I'm not a medical doctor, but I often did cross-examine them when I was a practicing attorney who is now retired after more than 30 years. Kyle is here. Bullcorn, coup contra coup is an internal collision of the brain with the skull. Bats, sudden decelerations, etc. Thank you. Thank you so much. Kyle? Team Wicked Smart versus Pure Wicked is here. What about falling on a basement step then? Ah, yes. Or a bulkhead step. Yes, the concrete ones. Dr. Russell is the goat tuning in from Norway, says, I think Brennan is so used to arguing things for the defense side and does whatever to create reasonable doubt that he's forgetting that he is the Commonwealth here. I've often thought that too. Norway is watching. Norway is here. Motions in CPA says, who are we kidding? Bev doesn't care. She's about to allow this nonsense with her annoying allowed and initials likely zero elaboration. Thank you for your super chat. I'm way far behind on these. A reasonable doubt, I'll allow it. Thanks for your 10. Says my head popped off and is rolling on the floor, not because of a bat, but because of Stanky's unintelligent stupidity. Thanks for your super chat. Audrey's here. It says it's coup contra coup, not split into one term or the other. This is in grading as cartoid. Yes, coup contra coup. It is contra coup, not counter coup. Thanks, Blessed in Texas. First question on cross says Josh, Dr. Wolf, did you examine John O'Keefe? Exactly. I don't think Dr. Wolf should be allowed to opine as to his manner of death. That's just me. Judge Beveridge is corrupt, says, when do Hanky's pants spontaneously combust? Thank you. Hanky's dead body magic dust. Thank you for gifting a membership. Mickey says all Bev knows is convict Karen and kiss ass to the Commonwealth. Come on, 47 pieces, Bev. You can't, then you are in on the joke for sure. Yeah, she thought the 47 pieces was referring to the glass. She forgot it was the taillight. That was back during the argument on the motion for the exhibit. during one of the MSP crime lab technicians' testimony. Janelle, thanks for the 10. Bevan, our good friend Hank, irritated me on my commute to work this morning. Thanks, Melanie, for making this trial more bearable and your expert and amazing commentary. We love you on the mods. Oh, I love you guys as much, just as much, if not more. Kita G, thanks for the 20. I wish Karen would stop doing interviews. She's only given the prosecution ammunition to twist her words. Perhaps she's getting paid for these interviews, but nothing good will come from these interviews at this point. The answer is no, there is no payment for these interviews. And also, I agree. I think she said a lot of things, or they edited what she said and cut out a lot of the context of what she said to make it twist their narrative. Originally, from what I heard Karen say, the director of this Discovery ID documentary, which is in several parts, I think 2 of them dropped last night. I watched it. I think 2 more parts are dropping tonight, and then the 5th part is dropping on Wednesday night. There were a lot of things that she said last night that are going to come back, in my opinion, if they're shown at trial, that are not going to be good. She did say that she had 6 drinks, but again, we don't know the context. I'm going to have to go back and watch it again, but maybe she said they poured me 6 drinks. I didn't drink them all. But they don't get paid for these interviews. And so therefore, what is the upside? I know she wanted to tell her story, but I have to agree with some parts of that.
Session may be seated.
Back to court.
All right, so Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long.
Tell us
I
what
want
motion
to
it is.
formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there's a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
Okay.
Martin Weinberg. If in fact the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
Who knows when
I
the
wish I
federal
did.
court's going to
I
decide?
don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, I believe that whoever it is that is appearing for the Commonwealth, or for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right, thank you very much.
Of course.
Does it make sense for me to hear from Mr. Schillinger directly, or Or do you want to handle this, Mr. Brennan?
Schillinger is their appellate attorney
Thank you.
for the Commonwealth. Oh, here he comes. We're going to hear from Schillinger. Caleb Schillinger.
Good
He's the
afternoon. So we do need you to
appellate
say your
counsel for the
name.
Commonwealth.
Good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works. So why don't you tell us?
Oh,
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which won't. At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members. And to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule, that would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
20, 40?
I don't remember what I put specifically, but I think if we have full trial
Yeah.
days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
That'll never happen.
Mr. Jackson?
No full days in this courtroom.
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
that
Wait, I'm sorry. Did he just change his answer to 24? Hold on. There's never full days in her courtroom. There's Taco Tuesday, half day Fridays, stay in the Cape Mondays. Come on. They don't work past 4.
Days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously
24 said
is
McLaughlin.
somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay.
Don't throw darts.
All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional.
Here's what we do in New York. Here's what we do. Sometimes we do pick and go, where you pick your jury and you go. Sometimes you do pick and then there's a different start date and you fill the jury panel in on that. You say, okay, we're picking today. This trial's not going to start until May 1st. So let us know that you're available. That is something we do in New York. I don't know what the hell they do in Massachusetts, but let's hear what she's got to say about that.
Months in order to, if we change the date. So that's very problematic. So
Not really.
I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure.
Is this going to be the end of the day? It's going to be the end of the day? They're going to break before lunch? We thought we had the whole full day today together. I don't know. We'll see. Maybe they're just going to go to lunch and then come back in the afternoon because they're supposed to have a pretrial conference as well. In addition to these motions in lemonade. Misty and Eddie, Kevin, been around for a long time. You'll see a lot of people with their, because the closed captions call Mr. Yannetti, Misty and Eddie. Sometimes they call it Misty Eddie, or chat, tell me what else they call him. Other things too. My brain's dead right now. Ooh. Mr. and Mrs. Smith, thank you for your 50. That's very generous. AJ has big supporters here in LA. I love LA. Reed is innocent. This judge hates Reed and her attorneys. We love Alan Jackson here. We have an emoji, smooth as butter, that we invented just for AJ. He's smooth as butter. And we love him. And I love LA. I was in Hermosa recently for one of my last vacations. And if I could move to the South Bay, I would be there in about 10 minutes. You may see me there real soon. Thank you, Mr. and Mrs. Smith. Mickey says, thank you. Suddenly went from knowing all things to number all things medical. He's up there trying to act like he's a doctor now. Yeah. Thanks, Mickey. I dig. I know what you're saying. And Miss Jules from Florida is all better now, girl. I'm glad. I'm glad to hear it. Sweden is here. Karen Reed is scientifically innocent. Thank you, Angela.
All right. So we'll see everybody back here, not tomorrow, but Thursday morning at 9 o'clock. That'll give you time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will, thank you, Your Honor.
Okay, so see you Thursday. All right, thank you, everybody.
That's it.
All rise to the court, please.
I don't know. It kind of sounds like she's considering perhaps adjourning the trial past April 1st. Let's take a look on the walkout. Take a look at some facial expressions. We can see. Idiot when gifted 10 memberships. Thank you so much. That is so very sweet and kind of you. I see Christina Rex in the back in the print dress. She too was in the documentary last night, as was Ted Daniel, who is sitting to the right of your screen from her with the glasses on. He's a local Boston reporter. That is him, right?
Don't get too close. I don't have anything to say.
Hot mic.
I will, I know.
Hot mic. And we're out. We're out. They're out. Well, that was a very exciting start to the morning. That was sort of like a big bang finish with Alan Jackson and Eliza Little being allowed to stay on the case, but we really, really, really weren't sure what she was going to do. That was crazy. Thank you, Michelle, for your super sticker. Thank you, Sons107, for hanging with me for 9 months and for thanking me. The Goodmans are here. They gifted 5 memberships, and I love you guys so much. Thank you so very much. VDC says, I told my son the Karen Reed trial was about to start again. He said the one where everybody butt dials to cover up a murder. Pretty much. Thanks for your super chat. Vi Craven says, rotating. She interrupts AJ every time. Tell me everything. Never. Hanky Spanky Herman Haskell. His alt ego name. Thank you, Vi, for your super chat. And then also says, Mickey says, yes, view all the headlights on that lawn at night, as well as a plow driving by with massive lights. I think the view would be best done at night, but you know they don't like to pay overtime in Norfolk County. It's not going to happen. Get it, Elizabeth, said Ms. Jules from Florida. Thank you for your 10. Breenan's lack of candor. Wheelie Twubble. Oh, well done on the name. I don't know. That just sort of came out like an Elmer Fudd thing that I said earlier. I need to add Nazareth, this flight tonight to the playlist for AJ's Red Eye Flight's great one. I think I put the playlist for Karen Reed trial in the show notes. If not, it's in yesterday's show notes. I got to add it, but we have a playlist for this trial. Jay says, do we all notice how every time the defendants need to argue a motion, Bev constantly interrupts, but when the Commonwealth is presenting, she doesn't say crap. Oh, we notice. Thanks. Up top puppet. They can watch closing arguments like the rest of us on YouTube, referring to the Alberts and the McCabes and Higgins. Thank you. Biased beverage. Thank goodness for Melanie being able to talk me off a cliff. I would not be able to watch this anywhere else. Oh, you're very sweet. Thank you. Make sure everyone, if you wouldn't mind just smashing the like button. If you are leaving us, please on your way out. If you're hanging, please just close out your chat and hit it because it helps the algorithm. Jonna, on a break, can you discuss what sanctions mean for AJ and Elizabeth Little? Well, sanctions could be any type of punishment, like money, or like precluding an expert from testifying, or pulling their pro hoc vice status. And luckily, we don't have to discuss that because she said there won't be any sanctions, right? So there's that. She didn't say that she was going to come back and decide sanctions later, right? This is 10:30. You wrote this. So, Spacey Travels in and on Nantucket. Thank you for pointing that out to me. I appreciate you. FYI, I talk back to you like you can hear me, says Amy from 406. I can hear you, Amy. I can hear you. Can you hear me? I am talking back to you. Miners Cal said, why don't we change the position of where the O'Keefe family is sitting and Karen Reed's family are sitting? I agree. The Penny McGee trial, which was in the same courtroom with the same judge, was a bench trial, and the positions were reversed. And I think that is a more fair way to do that. I don't think that the O'Keefe should be sitting in such close proximity to Karen Reed. And I don't think she has not decided that motion on whether the McCabes and Alberts are going to be allowed in during the trial when they are not testifying, and whether they're going to be allowed in at closings, right? She took that one under advisement. And so I think, in my opinion, that they should be flipped. Right. It is the defendant's fair trial thing, or constitutional right that is at issue here. Thank you, my nurse Kel, for your super chat. And then Jay Pearl pointed out, Aiden wasn't allowed in the courtroom when the McAlberts were there because they said he'd intimidate them, but they can be in the courtroom when the jurors say they felt intimidated by them. Right. Correct. But we don't know. Does anybody know if Aiden Carney's arraignment is going to be televised or is going to have a Zoom feed at noon? Because we can pivot to that on another stream. And if anybody has that Zoom info, if you want to email it to me, fanbase@mlittleLaw, fanbase@mlittleLaw. We can pivot to that on another stream and watch whatever's happening on Aiden's case at noon, because we are not coming back on the Reed case until Thursday at 9 a.m. So let me know. Thank you, Boiled Frog. In appreciation of your dulcet tones, Melanie, your channel, your rules, go get them. Thank you. I appreciate you so much. Malone Lee's Law said that Jackson asked Jen if she and Mrs. Proctor talked about the case, and Jen launched into a speech about being harassed. That is right. That is right. You are correct. My nurse Cal came in again and said, more because Brennan says so. Sharing and ordering somebody to do something are two different things, like a parent saying jump off the bridge. Right. It is in Stoughton District Court where Aiden's case is at noon, I believe. And so I don't know if Stoughton District Court has the Zoom feed or not. If it quacks like a duck, says, ugh, I can't with this woman. Lally is the one who lacked candor with the court, solicited a false statement from Buchanan, and submitted a misleading and distorted video. Day 1142, free Karen Reed. Thank you. Thank you, Suzanne, for sending me the Zoom information. It's audio only. All right, you guys want to do it? Let's finish up these super chats. Amber Dawn, them Johnsons, thanks for the 5. Love y'all. That person next to Peggy O'Keefe, possibly Officer Don O'Keefe's niece. I don't know. I pray for those two kids. I do too. I know. Mel in this chat, prayers for the best in their lives. Thank you. I appreciate that. Amber Dawn, I appreciate that. Dirty Hanky says, thank you, Melanie, for your dedication to the truth. Thank you for your 10. And Mr. and Mrs. Smith, I already addressed this. The 50. AJ has big supporters here in LA. Love it. A lucid visionary girl. Thanks for the 10. Being a health provider, contra coup can be caused by a fall or a blow to the head. But yes, most cases are due to the brain striking a stationary object or surface like a weight bench due to the situation. Thank you. Vet girl, how many autopsies has he done? Surgeons treat subjectively and objectively. How does he explain blunt force trauma if his patient is deceased? Thanks. I agree. Oh, sweetie, no. Dr. Wolf has no background in pathology. He did a transitional year internship, multi-specialty, and a residency in neurological surgery per his CV. Thank you. Casey Go, thank you so much for your first super sticker ever on a channel, and I am honored that it was me. Thanks for the 20. Miss Holmes 66, right, Bevan? All this publicity has been created by the Dirty Rotten Defense, right, Auntie? Mm-hmm. Septic Hank has been a member for 11 months. Best place to watch this mess. Thank you. And Mrs. Smith, Mr. and Mrs. Smith came back in with another 50 and says, great to hear. We have a trial lawyers university in June. That's awesome. You're an attorney as well? Rock on. Hope you were not affected by the fires, as so many were. Prayers up for everyone in the Pacific Palisades, Malibu, Calabasas area that were affected by the fires, Hollywood Hills. Watching the Only Fan, why do we adjourn? Don't we have a million more motions in Lemonade? We do. Do we do Turtleboy's hearing now? I think we're going to do that. Will it be on Zoom today? We're going to dial in. Let's redirect ourselves. Where do I find Karen's interview from last night? It's on Discovery ID, and I heard that it is also streaming on Max. So you can, I think, find it on Max today. Does anybody else know? Let me just set up this live stream real fast, and I will teleport all of us over there. So that we can do the audio only. All right, my friends. I think it's only on Max. All right, let me set up the teleportation for you so we can all go over. And if you are so inclined to come with us, if you will, to watch the Aiden Carney hearing or listen to it anyway. I think you guys said that it's going to be audio only. We're going to head on over there. Thank you so much to everyone for watching today. Please smash the like button on your DNA. I promise you that they will not get to your DNA. Hold My Halo says contra coup has to be preceded by coup. So it has to be coup contra coup. Thank you so very much. Hold My Halo. Thank you, everyone. Smash the like on your way up. Moderators, I love you with all of my heart. I couldn't do this without you. So, I couldn't. You're amazing. Everyone thank the mods. And smash the like on your way out. Let's head on over to listen to the Aiden Carney hearing. I'm going to teleport you there. He's being arraigned for an incident that happened the other night at D&E Pizza when he came out of CF McCarthy's with the Glara, Meredith, and Nan Gallagher, and he spoke into the video surveillance camera at D&E Pizza. Chris Albert sent a email to Tully with the video of him, and now he's going to Stoughton District Court. There's a chance they may revoke his bail and send him back to jail. So you might want to head on over and see what goes on in this county of Norfolk for, selective persecution and prosecution of their laws. I'm going to teleport you over there. I love you all with all of my heart. If I don't see you soon, I'm going to die. Ipsy Dixit says, and so today, Brennan, aka Icarus, started to melt. Safe travels, my friends. I will see you over there in 3, 2, 1. Stay cool, stay kind, stay classy, stay calm. Peace.